So in Texas, this is a legal definition, and you can see the citation there from the Business and Commerce Code. It's a transfer made, a fraudulent transfer, which is what we're trying to avoid here. It's a transfer made with the intent to hinder, delay, or defraud any creditor of the debtor and or without receiving a reasonable equivalent value in exchange of the transfer obligation. So again, we're not trying to defraud or hinder current creditors. So a person, if a person uses non-exempt property to obtain an interest in or improvement to or pay a debt to a person which will be exempt with the intent to defraud, delay, or hinder an interest of a person entitled to receive that property, again, these are fraudulent transfers. You know, this is what we're trying to avoid. And if you do commit a fraudulent transfer, well, then the creditor has a right to go to court and, you know, seize that transfer. So there's, in addition to the fraudulent transfers, there's a lot of potential penalties and liabilities here. So civil penalties, again, you can get a malpractice claim against you. You know, you could be liable for fraud, conspiracy, aiding and abetting, racketeering, corrupt organizations act. Think about, you know, the mafia bosses, you know, up in the Northeast, you know, the attorneys, you know, they help conspire to, you know, defraud the government and tax evasion. Well, again, we don't want to put your bar license at risk here. So we have to be careful with what these penalties are. In bankruptcy law, again, there's bankruptcy penalties, and they could be civil, even criminal penalties for doing fraudulent transfers with intent. There's Money Laundering Control Act. So we were talking about penalty considerations for fraudulent transfers. Again, we're like I mentioned, there's civil liabilities. There's penalties under the Bankruptcy Code. There's Money Laundering Act and mail and wire fraud. Okay, statute of limitations. Typically, there's the 4-year statute of limitations for fraudulent transfers. There's 1-year statute of limitations as well. Again, there could be 2 years depending on what type of act that we're looking at. Under the Bankruptcy Code, it can go as far as 2 years to 10 years of the fraudulent transfer. So again, the bottom line here is we need to be mindful of fraudulent transfers when it comes to our clients when doing asset protection planning, because we don't want to get them into trouble, and you don't want to get yourself into trouble either for malpractice.